Hi, welcome everyone to researching and analyzing legal records retention requirements. So we've got Jennifer Chadban and I'm Rick Serber, CRM IGP. I'm a senior analyst and licensed attorney in Zazio's consulting division. I'm also the manager of the legal research division. And Jen, I'll let you introduce yourself.
Hi, everybody. I'm glad everybody could join today. My name is Jennifer Chadban. I am a senior analyst and licensed attorney with Zazio's consulting division, and I know I've met a lot of the attendees that have joined today, so thanks for joining us. So today, topic is legal research, analyzing requirements, applying them, and making decisions about retention periods and other retention schedules decisions. So a roadmap for the topics we're kind of going to walk through. First, we're going to talk about the process of actually conducting the legal research, and then get into that application and mapping process. So once all of the citations have been kind of gathered, or you've narrowed down that pool of research that you're looking at for your organization, what are the methods for applying to the schedule? And then the actual analysis that goes into mapping or linking the citations to your retention schedule. And then we're also going to kind of talk through some of these common pain point, the questions that we often have come up, from various clients. And I think that, walking through these will kind of be helpful for all of the participants if, you actually get into this, or might answer some questions you've had come up. And of course, this is an interactive session, so any questions that come up, as we're walking through all of this material, we want it to be interactive as much as possible. So please feel free to provide any comments or questions. You can type them into the chat, and we'd be happy to talk about those. So for this first part, I'm going to hand it over to Rick, talking about the legal research. Rick is also the manager of our legal research department. So he's got some very, very poignant insight on this, and I'll hand it over to him.
Awesome. Thanks, Jen. So, jumping in, I think the biggest thing that we make sure to do when we're going to conduct research is we do a lot of planning to try to make sure that we understand everything that we're going to be collecting. We've got a strategy for what we're going to be looking for, and we try to organize it as much as possible, because without that plan, we have found that if you have to go back and grab something that you didn't initially collect, it could be very, very inefficient. And so the first step in the research planning part is to know who you are as a regulated party. And for me, it's clients that I'm researching, but for many of you that are planning to conduct research yourselves potentially, it could be for the company or the government entity that you're working for. But this first step is crucial, that you understand how you're regulated, and you understand where you're regulated within the different sections of the law, so that you don't miss applicable sections. And so the way that we usually go about this is, with most clients, we have an initial information collection process. You would be, if you were conducting this research internally, you would do it internally with your own organization, but where we're going to be sending out questionnaires to knowledgeable stakeholders that know how your company is regulated. We're going to be asking about any regulations that they already know about, any kind of pain points, government audits, things like that. Which regulators are they working with? Who are they reporting to or filing with? Those types of things, because those are all instrumental. A lot of this you can find, just kind of by having an understanding of the industry that you're in, and a lot of the different activities are going to be available potentially on, company websites, things like that. But you can also find them oftentimes on public filings. And so, you know, I think the stakeholders are always a huge component of it, and going to give you a lot of information. And so we really recommend utilizing stakeholders where you're unclear about how you're regulated. And then I think that, you know, the most valuable resource to get started, if you've already got a records retention schedule and it's been drafted, you know, in a way that in a good way that provides all the information that you need, you know, it'll tell you a lot about your regulated activities and processes, and so, you know, that's always the place where we start. All of this information should be used to create a list of regulators to target and subjects to target under those regulators. And generally, you know, which areas of laws where you're going to focus. You know, my team has conducted research for many types of regulated parties, but every company is different. And so we always take a step back and do this exercise to make sure we understand the processes performed and the regulators for each process. Once you kind of have the strategy down, it's time to actually dig into those sources. And you know, I think the government sources are going to be the most, you know, they're the primary sources. They're going to be the areas where you're going to find the legal requirements and the everything that is directly from the government. But unfortunately, the official government sources oftentimes don't have the best search capabilities. And so that's where we often look to database providers, you know, such as Lexis, Westlaw, CaseMaker. You know, they oftentimes offer more robust search abilities that allow you to use Boolean searches, and it makes things a lot easier. It makes it easier to find the things that you're looking for and to find the things that you need. We conduct international research oftentimes, and almost everything internationally is going to be done using the official government sources. And, you know, oftentimes we're having to run searches document by document, you know, where you open up each law and you run a search of it. Sometimes they're not even character recognized. And so we're having to use an optical character recognition software to even be able to run searches of it. And so that's worst case. I guess worst case is one step further when it needs to be translated as well. But yeah, I think most sources within the United States and within Idaho specifically, you're at least going to be able to run a simple search on a website, which is a huge improvement from that. And then yeah, if you're utilizing one of those database providers, the Boolean operators will be really useful. They'll let you that'll cut down on the amount of time that you spend kind of wandering around looking for the right things considerably. And oftentimes they'll even include focus or pinpoint searches, which are secondary searches after you've run your initial one. It's a search within a search. So one thing actually, let's go back because I wanted to mention, if you do have the opportunity to run Boolean searches, I think it's worthwhile to spend a little bit of time working on your Boolean search, because it'll pay off dividends in the end if you get it right. Our search is something that we've been working on for over a decade. You know, we've met with our database provider and gotten their opinion on how we can make it more efficient. But, you know, even something that we've built on for that long, and even something that we have used has, you know, it still results in a lot of mishits, and so false positive hits, which I think is just something you're going to have to deal with. But I thought I would give you a tip in creating your Boolean. If you have the opportunity to create a Boolean, I wanted to give you a tip. Most of the time, the database providers will include a heading section. And almost every time that heading section mentions record keeping, you're going to have a good hit. And so consider using your Boolean to search the heading section for the term record keeping, and then use an OR operator, and then kind of customize the rest of your Boolean to target a combination of terms that are used for preserving records like keep, kept, retain, and then terms for the durations of those records. Years, months, days, those types of things, expiration. We've been successful with that type of format. And then the types of requirements that you're going to be looking for, of course, I think it goes without saying that if you're doing research for a record keeping project, you're going to be looking for records retention. Keep in mind that many of them don't specify an actual duration. So they're what we call non-stated requirements. That will impact your Boolean if you want to consider those. We utilize them for some clients we don't. They really just say you have to keep the record and don't give a relevant time period for how long you have to keep it. So how useful that is debatable. Some clients want it linked for reference. Some clients don't want to see it because they think it just adds noise. Something to have to decide on your own. Also, the retention periods specified aren't always clear. And I've got the example permanent listed there. This oftentimes means actually permanently, so they want you to keep it forever. But oftentimes it also has to do with the format of the records. So they want you to keep a hard copy record or something that's in a durable medium, and they're using the term permanent to mean format. And so you got to be careful on that and kind of dig into the language to really understand. Another type of requirement that we target are privacy requirements. There are two types of privacy requirements. There are general ones, which we'll talk about a little later, but they, typically require retention for no longer than the purpose for collection or while needed or something like that. And then there are actual compelled privacy requirements, which specify that you can't keep a record for longer than X period. And so, we recommend grabbing both of those because I think both of those are relevant. We also grab handling requirements. And so I also mentioned one, I already mentioned one with the permanent format, but there are a lot of other format requirements specifying mostly that you can keep it electronically if you follow certain protocols. Sometimes you still run into, wet signature or requirements like that permanent one that we discussed where they're wanting you to keep it in a paper format or a certain format. So we like to grab those because I think those are relevant to, the records retention schedule and what it's supposed to convey. The final one that we look at usually is statutes and limitations, which in and of themselves, they don't mandate the retention of records. They instead limit the duration within which a legal claim can be brought. So while retention isn't required by the SOLs, the duration does provide context in weighing the risk of over-retention and under-retention. And so oftentimes clients want those, so that's something that we usually grab, although you want to have a strategy with how you're going to apply those, which I'll discuss a little bit later. But again, I want to emphasize that you really want to be over-inclusive in what you capture, because having to go back through everything you've already searched and pull requirements that you initially excluded is really time-consuming and redundant. So you're going to be grabbing a lot of information probably, potentially hundreds of different requirements. And so I think it's important to organize the information that you find into fields is what we do. Some of these fields might not be easy to figure out, but a little analysis might be required to figure them out. But these are the fields that we capture. You want to know who the requirement regulates, because the regulated party isn't always going to be a one-to-one match. It could regulate certain aspects of what your company is doing. They're not all going to say, X company or companies or employers, for example. Some of them are going to be a little bit harder to figure out. And when we're going through the research process, we're over-inclusive and we're grabbing these things and we're documenting the regulated party so that at a later time we can analyze whether we think that those are really appropriate and applicable and should be considered as far as, adjusting retention periods goes. The description of the records is usually pretty easy. It's usually going to be straightforward, although sometimes it's not. Sometimes you have to look at definitions. Sometimes it references another section. You have to go there and you have to kind of track that down, but it's usually the easiest part of it. The retention period is usually pretty easy. And then, the heading is really just to make sure that there aren't any modifiers within that heading or the sections that it's under that could, change who the regulated party is. And then even a snippet of the regulated text, I think, is good to have. Now, when you're capturing these, we call these citations when we've grabbed all of these different fields and connected them together. You're going to need to try to figure out how granular you want to go. And where retention schedules are kind of trending towards being bigger bucket and less granular, I think it's important for citations to still maintain that granularity to the extent possible, because you don't want more than one retention period being retained in the same citation, for example, because then it's really hard to track what that citation is requiring. Or, for example, multiple regulated parties and multiple records and not knowing which regulated party is for which records. So we typically break out these citations in a pretty granular way. For example, even a requirement that says you must keep these records for 5 years or until settlement, whichever is longer, we would actually break that into two different citations, one for the 5 years and one for the settlement, just so that you can analyze those two together and know which one you're going to be basing a recommendation potentially on. So I think the granularity in the citation collection is a good thing, which is kind of counterintuitive to the big bucket retention schedules, but I think that's something to keep in mind. So once you've got all of these citations that you've captured and you've completed this research process, it's time to try to figure out how they map and apply to your records retention schedule. And I'm going to hand it over to Jen to talk about that aspect of it.
Thanks, Rick. And I'll be the first to admit that I think I accidentally turned off the webcams when I was trying to adjust what I was seeing here on my screen for the presentation. So somebody made me an organizer. It's their fault. So sorry about that. So I'll just jump back on since I'm going to be talking about the application mapping. So transitioning away from, you've kind of cast this broad net, so to speak, and now we have all of this research in front of us. Now what do we do this? What's the method for actually getting it linked to the retention schedule and properly considered? So if we can go to our next screen, my presenter on here.
Yeah, we're at are we on the determine relevant citations? Okay, next screen.
Oh, yeah, here. Yeah, this is perfect. Thanks,
okay.
Rick. Okay. So looking at it, a lot of emphasis on the regulated parties. So Rick's kind of walked you through that process for how do you understand how you're regulated, making sure that you are looking at all of that relevant research. And then it's really a matter of kind of filtering through, you might be leveraging a database for research. And in that case, it's probably a little bit more, inclusive as to what's in there. So, you'll be kind of running searches to narrow down those regulated parties that are relevant. And that's kind of the first step, I think. That's the best way to really hone in the focus for that pool of research that you're going to want to be considering more closely. And I think a good strategy is to kind of be a little bit over-inclusive as to what you're looking at. Regulated parties can be tricky. You might get into some of the details of a regulated party and find that it is directly applicable to your organization, or in some instances it might not be, because there's definitions that are associated with it that you'll kind of need to go through to verify. So for that first kind of broad pool that you're considering, I think it's a good strategy to be overly inclusive as to what you're considering. There's other details within the citation that are going to be really helpful as well, and that you'll want to focus in on as part of your analysis during the mapping process. And so that is, looking at descriptions. The descriptions give you that guidance as to, okay, these are the records that are regulated, you know, and that provides you guidance as to which record series you're going to be looking at, as far as where you're going to want to link and consider what that requirement is. And then as well, you know, the headings similarly kind of provide guidance, and maybe at a higher level, I think that it's helpful. It provides a little bit more of a context. You look at the headings and you'll understand now, okay, the citation, you know, the regulated party just says licensee, but then when I get into the heading, it talks about, you know, one of the chapter headings relates to, you know, nuclear, or, you know, that's maybe the title of the law, for example. Those are the categories of information that you're going to capture under the heading, and they are also important, I think, to provide that context for how you want to apply and consider the citation within the retention schedule. So keeping all of these in mind, we get into that next part, which is, if we could go to the next slide. Yeah, these details and that actual process that we're looking at. So you have the citations in front of you and you have your pool. This is where you're kind of doing that analytical process, and oftentimes this is a citation by citation process. Rick mentioned, you know, maybe with your organization, you're going to be looking at hundreds of citations, and I think that's kind of a little bit, you know, it just kind of depends on how heavily regulated your organization is, what, you know, how many different jurisdictions you're considering. Some of our highly regulated clients, even if they're just in one jurisdiction, I mean, those citations, when you're thinking about, you know, maybe everything you might want to be looking at, format, you know, the handling and all these different ones, for example, you could be getting into the thousands. So a good strategy as to how you're going to kind of tackle that is a good idea. When you're looking at the citation details, that's where you're kind of going into that. Okay, I have my schedule in front of me. You have a good understanding of how your organization's retention schedule is organized. So if it's departmental versus functional, you might have a bit of a different strategy. Where it's departmental, then you might be applying a citation as it relates to multiple different departments in multiple places. So have these things in mind as you're going through. Also, when you go through, that's kind of, you know, where you're going to go ahead and align the record series. And this is a little bit theoretical right here, but keep in mind, I'm going to walk everybody through some exercises so we can just kind of talk through this with some real life examples too. So I'm just kind of giving an introduction to these as well. We talked about mapping broadly. And so there's really, it goes to that strategy and understanding that in some instances, the citations you're looking at might have some details behind them that would make you decide, well, that's not really broadly applicable, or that's not applicable at all. So one thing to keep in mind is if you were to kind of do that analysis on a citation by citation, you know, level, that would be really time consuming. So, you know, our recommendation and our methodology is as long as the regular party really looks like it's relevant, you know, go ahead and link it to the schedule. This is showing your due diligence. This is showing, you know, you are looking through all of these citations, and really what your focus is you're wanting to focus on those that are impactful to the retention schedule. So those that might affect the retention period, whether it's your baseline, whether it's your country retention period. Once you have all of that research kind of linked and in front of you, then you can really continue to focus and narrow in on those citations that are impactful to the retention schedule. And let's see. And I think okay. So talking about those impactful citations, these are the ones that will, you know, impact the retention period, whether you have a global retention period, whether you have individual retention schedules for various jurisdictions, whether you have, you know, a singular kind of baseline retention period for your retention schedule. When you get into the details of these citations and you're identifying those that are impactful, what you're really looking at is you are making this analysis, is this going to drive a different retention period? So the determinations are, you know, determining retention drivers for the purposes of potentially, you know, creating a harmonized, whether it's a globally harmonized retention schedule, or what we're seeing now is even clients that have, you know, solely U.S. domestic schedules, is they're starting to look at potential state exceptions under some of the privacy issues that we're running into, and various exceptions. And then you're also kind of making those decisions as to, okay, how am I going to adjust the retention periods based on this? Am I going to need to lower the retention period due to these compelled privacy requirements, or are we going to lengthen the retention period? You know, an example is a lot of our domestic clients will look at the workers' compensation retention period for New York and say, well, it's 18 years. Do I really want to make, you know, the retention period for workers' comp 18 years for all of our schedule and all of the jurisdictions, the state jurisdictions? Because it's a long time where, you know, the states might have much shorter retention periods for workers' comp. Or do I want to create an exception for New York? Is it going to have a unique retention period, whereas, you know, there's going to be a lower retention period that's for all of the other states? So these are kind of the decisions that are being made, and really the focus is determining what are these citations that, you know, lead to these types of decisions, and what are the changes that need to be made to the retention schedule in order to elevate that compliance and make sure it's compliant with the legal requirements. So getting into the examples here. So we have some exercises to kind of go through and illustrate some of these points we're talking about. So here's our first one. This is, and keep in mind, you know, an application strategy for a citation will really kind of depend on the individual schedule. And as we mentioned, you know, if it's a departmental, if it would be applied a little bit different. If we're thinking about a functional schedule, you know, there might be a different way to apply it. So the idea is to really kind of make sure that you're considering it broadly and linking where it might be relevant. Here's an example where it's a little bit tricky. So we've got this Washington citation, and it is the regulated party we see. So let's say I am my organization that I'm looking at here, and we're a financial service provider. So regulated party mortgage brokers or loan originators. So that's something that's in line with the services that we do provide. We are loan originators, so we would definitely want to consider this. Now I get to the record description and going through all these different, you know, pieces, I may see it broadly kind of applies to books, accounts, records, papers, documents, files, and other information relating to the mortgage broker operation. So this, in a sense, can read pretty broadly. From a functional retention schedule perspective, I'm seeing books and accounts. This goes to, you know, potentially the financial and accounting, you know, function within the retention schedule. I might want to apply it there. Also, as demonstrated below, we've got this lending and credit card function. So this isn't industry specific. It really goes to those high-level business processes related to, you know, the client and customer services. So something that's kind of separate from finance and accounting. But then I see that we have within the description, the loan, the schedule title says loan and mortgage records, and we have within our retention schedule these records that document the history, case file of a loan customer from creation, etc. So, and I see the examples, you know, this really goes to those specific types of records that would relate to this citation as well. So there's some decisions to make. I see that the retention period is 3 years, and this kind of keys me off as well, because I'm really familiar with my organization schedule. I know that we keep our finance and accounting records for 7 years. I know that we keep all of our customer account records for, you know, account closure plus 10 years. So immediately I'm seeing, you know, I want to link this and consider it. And I'm going to consider it broadly because the language really is kind of broad. When I see records, papers, documents, yes, it does fall under brokers and loan originators and licensing. But it could apply, you know, fairly broadly. And I'm going to go ahead and link it in both of those functions so that I can consider it. But I recognize immediately it's not a driver. So I'm not going to really dig into this citation and see, oh, should I just only link it to this one record series versus another, and, you know, kind of be more concerned about how narrowly to apply it. But I want to, you know, consider it broadly, and so that when I get into everything that I've linked for all of those record series, that's when I can really drill into the details and see, is this a driver, and how's it going to impact my retention schedule? So another example here, under mapping exercise 2, it is a federal requirement, and it falls under Title 29 CFR, so it's a labor law. And I'm sure everybody, this is a great example of one of those core vertical types of requirements that would relate to activities of basically any organization. We see that based on the regulated party. It's the regulated party's employers. So this would, you know, broadly apply. And we see that the description is records of payroll, certificates, agreements, and contracts. So immediately this kind of keys me off to, oh yeah, let's go to our payroll function. You know, I see that this is, I'm drawing that distinction there. So this is where I want to link it. And I go to the payroll, and I also see we've got, you know, various record series. We have payroll accounting, employee payroll and direct deposit, and also, you know, time and attendance. You know, so you would want to consider it definitely within that payroll function and link to those record series where it's most relevant. This isn't a time and attendance requirement per se. Those are kind of their own beast. You see those at the federal level, you also see those at the state level. So I'm not really seeing that as, you know, the language of the description isn't super on point for the time and attendance record. But with regard to the employee payroll and direct deposit and payroll accounting, I think that those would be good places to really consider this. And one thing that's also kind of keying me off, or tipping me off as to maybe explore a bit further on this, is that I see that it relates to agreements and contracts. So that's where it also makes me think a bit more broadly for the retention schedule. And I'm thinking of employee contracts and agreements. Should I also apply this if those are being kept within the personnel record series? I would want to consider it there. If it's a very truly functional retention schedule and those agreements and contracts are kept within the legal contracts record series within a legal function, I'd also want to apply it there. So another example here where we can have one citation that may apply broadly. You know, if we were thinking about a departmental retention schedule, then this would potentially, you know, apply in multiple places as well. So go to our next mapping exercise. And it's not, I can't get it to forward. Oh, oops. Okay, back. All right. So here's one I thought it'd be interesting to kind of throw in an international requirement. And this is one that we, you know, it may not be relevant if you're only domestic, but I still think, you know, it's one of those that's helpful to talk about because you know, it's a broad requirement again. So it talks about accounting records and supporting documents. So that's where you're making that analysis decision again. How broadly do I want to consider this? I see that it is a 10-year requirement. It's pretty lengthy, and you know, and for our clients that just have only considered domestic within their schedules, this ends up being a driver for their retention schedule. Now, one of the things to think about is when I see accounting records and supporting documents, you would probably want to kind of think of and come up with a reasonable application strategy for this. And so where you're seeing it's talking generally about accounting, I'm looking through the heading, I see it's talking about commerce in general, it regulates traders, 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 and the general obligations. So we're looking at this as like a general accounting requirement, how broadly to apply this. One thing that's helpful here is to, you know, come up with a strategy, you know, which are the record series that are really impacted by this? You know, what would we consider to be kind of substantive type of accounting records? You know, maybe it doesn't go to forecasts, you know, those really only need to be cut for 3 years. Maybe it doesn't really go to those just basic budget records. Those really generally have a shorter business operational and they don't rise to that level of accounting records. So that's where you're coming up with a strategy and say, you know, I'm going to apply it to these records. So I've kind of pointed out 3 example type record series that really are representative of more of those substantive higher level accounting records where from a reasonableness perspective, you know, this is where this type of retention requirement is intended to apply. And so that's how this is an example of a broad language, and this is very common in a lot of international jurisdictions that they have these types. You know, these old commercial codes are based on actually an old Germanic commercial code, and a lot of the countries, including the Latin American countries, have replicated it in various ways, and they tend to have really antiquated language and this, you know, and be a little bit difficult to kind of understand. So that's kind of some of the challenges that you run into as well with international. We do see it domestic as well too, but this is a really great example. And let's go to our next and kind of final mapping exercise here. So this is a great example of one of those compelled privacy requirements that Rick kind of touched on. And these are definitely becoming more and more common. They are common internationally because there has been such this push for privacy, and you know, they have definitely been, I think, ahead of us on a lot of different things, but these are also things that we are seeing more and more domestically. So here's an example from Utah, and it talks about and you'll see within the citation, one thing that's helpful to note is this abbreviated citation. When you're looking at citations, by actually having in front of you just an idea of what the retention requirement is. Here we have something that we use internally, and our clients find it helpful, but it also, it notes, it says NLT MEV. What this is an abbreviation that says no longer than mandatory with an event requirement. So here the Utah law requires the information collected during an initial selection process is retained for no longer than 2 years after that decision is made or after last contact with the employment prospect. So this is definitely a data privacy law. It does have a carve out. It also says that if there's another legal requirement that mandates that record be retained, then it may be retained longer. So you look at this and you're probably thinking, well, you know, this is kind of in conflict a bit with some of the EEO requirements and recruitment records and the retention period for those, which generally are 1 or 2 years, depending on what type of regulated party you are. And then for some types of government contractors, government service contractors, it can be longer than that. So that's where it's kind of, it gets a little bit more murky. Now you're not only considering, you know, the longer requirements, but the shorter requirements, and then also how they interact with each other. Does my organization have a carve out which says that, you know, because due to the way that we're regulated federally, and pursuant to this requirement, we actually have to keep these recruitment records for 3 years, and therefore, you know, we don't have to really consider this requirement. So that's part of an analysis to look at that. And I see here we have the record code is HUM 25, and the title is Employee Recruitment. And so this is an example here where it's pretty easy to align it to your retention schedule. This is kind of a typical type of record series, but then, you know, it goes to that application analysis where, okay, our current retention period is position filled / withdrawn plus 3 years. Is that because you know, there's business or operational, you know, reasons? This is not an uncommon retention period to keep these records for 3 years, but it also kind of forces your hand in, okay, our business and operational needs maybe aren't, you know, aren't as valid anymore, where we might have a legal requirement that kind of contravenes, you know, what those business and operational determinations have been made in the past. And it forces you to take a closer look at the legal requirements and say, you know, maybe we should tailor this a little bit closer, and, you know, maybe speak with stakeholders a bit more, see if, you know, this, if we do have to reduce it, you know, is this still going to be okay for our business operational? And it really kind of is an opportunity as well to get a bit more sense of what your organization is doing with their privacy information and how long some of that really needs to be kept. And that's something that a lot of our clients are doing, even where, you know, there's not a compelled privacy requirement, but they want to see if they can try and align their PII records as closely with the legal requirements, and then look at those business operational needs as well. And whereas, you know, previously it seemed like companies were more, you know, comfortable absolutely making sure that, you know, records are being kept long enough for the legal requirement purposes, but felt a lot more comfortable, you know, deferring to those business operational, you know, needs where longer, even in some instances, much longer than what the legal requirements are. So it is kind of forcing our clients' hands to take a closer look at this kind of stuff. So this is a great example. We see a lot of biometric requirements as well, and some class actions that are even coming up as a result of some of these privacy laws already in the US. Okay, so we're going to kind of get into some of these common pain points, and certainly I think this is a super duper awesome opportunity to be interactive here. You know, if you have some pain points or some questions, this is definitely meant to be more of an interactive session. Rick and I are just going to kind of both, you know, talk through these, and you know, welcome everybody to share with us. You know, you can complain to us, and you know, we can kind of talk through some of the issues that you're dealing with as well. So.
Yeah, so Jen gave a great example of that compelled privacy requirement. This is an example of the general. And so this is the GDPR. You can see that it's requiring data subjects to keep identifiable information for no longer than is necessary for the purposes for which the personal data are processed. And so where do you even start to tie this to your records retention schedule? And that's, I think that's a good question. Our strategy is to review the records retention schedule and develop a methodology for how this is going to impact it. And I recommend that method because then you kind of have some structure and analysis to how you're going to be dealing with this type of requirement. The good news is for those of us that are local, there isn't anything that's analogous to this in Idaho, and there's nothing federally yet. But this is catching on, and it's spreading from Europe. CCPA doesn't go quite this far, but it does have some requirements that are similar. But the way that we deal with this is we review the records retention schedule and we determine which categories of records have personal data and PII. And so that's the initial step in the analysis. We usually work with clients to determine that, just because we want to make sure that we get it right, and we want to make sure that we're not being overly inclusive and including things that, maybe just have like a contract with someone's signature on it, but not actually a spelled out name or anything like that. And really depends on the jurisdictions what PII or personal data is defined as. So that's going to impact the equation as well. But once we've got this methodology and we know which categories are going to be included, that's where we're going to work with clients and recommend a strategy. Some clients are acceptable of a little bit of risk and maybe allow the longest record within a category of records if they have a big bucket retention schedule to drive the requirement for all of the rest of the records. However, some clients are doing what we've termed intelligent granularization, which is where they're actually moving away from the big bucket idea in certain contexts where privacy is involved and granularizing some things where it makes sense. We don't want to throw the whole big bucket idea out because it's still valuable, it's necessary, it's why we've evolved to it. But I think in some contexts it might be relevant, and I've got a video surveillance icon there to kind of demonstrate one of those, which is video surveillance. If you were to try to preserve the big bucket approach, many clients and many companies had included those video surveillance records within their security category generally. Well, that's a place where if we've got video surveillance and there's no incident captured, there are a lot of mandatory destruction requirements for those at very short periods, like 3 months or even 1 month. And so we don't want to schedule the whole category to 3 months or 1 month because there are valuable security records in there that you may not legally be able to destroy that soon. And so that we're breaking those out. We're breaking out a category that says video surveillance, no event, and we're able to then schedule them based on the individual compelled requirements that say how long to keep them. And so that, I've kind of digressed a little bit from these broad requirements, but I think that provides another good example of what we're doing with privacy and how privacy is impacting retention schedules. It's definitely a pain point right now for most people. As far as the mapping goes, Jen talked about mapping broadly, but then also analyzing with precision. And I think that's there's a balance there that needs to be struck. And it's a hard balance sometimes to reach because you don't want to just shotgun approach it. You don't want to apply a ton of citations all over the place so that there's really no relevant connection between the citations and the retention schedule. It just kind of it clouds the schedule and makes it more difficult to analyze the retention periods and establish what's legally mandated. And so we recommend that we recommend mapping with particularity. And if you do have a valid reason for considering a citation, map it to a category because that makes sense. But don't go too broad. Don't take a shotgun approach. We don't recommend this concept of legal groupings and just kind of shotgun bulk applying citations. I think particularity will pay off with dividends and that it makes more sense. Digging into definitions is also critical because you can have a requirement where you're looking at the text of the requirement and it says something, but then there's a key term that you have to go to a definition section to define that adds a layer of analysis or a layer of clarity that could maybe even mean that it's not relevant to as a regulated party. And so those definition sections should always be reviewed and considered, especially where citations are, in consideration for being determinative and making a recommendation to change something. That's where you really want to dig in, and you really want to make sure that this regulates you. There aren't any exceptions. Before those recommendations come out and you change anything based on that, that's the type of due diligence that we recommend. And then another thing to consider, a lot of clients come into our engagements thinking that every single category will be regulated and will have citations. And if you're applying broadly, maybe you've considered citations for every category, but in reality, I think as far as one-to-one matches go, really only a third to a half of the categories are going to be regulated. And that does depend on who you are as a regulated party. For example, a government entity might be even less regulated than that. Or, a pharmaceutical company or a utility might be even more regulated. Utilities specifically have some sections of the 18 CFRs, the Code of Federal Regulations, that have these pretty granular listings of records that they have to retain. And so oftentimes more of their categories are regulated, but it really does depend on who you are as a regulated party. But if you're not finding a citation for every single category, don't be discouraged. A lot of the categories won't have legal requirements. So Jen already kind of talked about the determinative citations and what you're looking to try to figure out. But these are the types of changes listed out that you're going to be looking for and you're going to be trying to identify. And I think the most obvious ones are those top couple. The increases. You find a requirement that's longer than your current retention period, you're going to try to get that changed and propose a change to that, and make sure that your legal counsel reviews that and reviews the citation that you're relying on and confirms that they believe it's relevant to you. Decreases, that Utah requirement is a great example of that. Decreases generally, so that goes more towards maybe those general privacy requirements that specify no longer than the purpose for collection. You're really going to make sure that your operational retention is designed based on your actual need and not just someone saying, oh, I want to keep these permanently, which we find a lot. I mean, that happens a lot. People want their records and they're very particular about them. They think of every potential contingency that they might need those records for. And, that's not really going to the true operational need of the record. And so decreases generally, I think, are going to become more and more important in digging into the actual operational need for the record. And especially in the privacy context is going to be, I think, something that everyone is going to be moving towards. You might also need some trigger changes. So, that the event before the number of years might need to change in your retention schedule. So if something is a flat 7-year and you find something that requires a duration of employment, you might have to recommend, a change to the trigger to align with that, because duration of employment is one of those things that's really hard to calculate and get a fixed period for. So those might be necessary. Sometimes we find legal requirements specifying a record that could be a gap. And so to the extent that you think there might be gaps, you can utilize the research to potentially do that. They're also a factor in consolidating and deconsolidating your records retention schedule, because if you go in and try to consolidate something and then you find a law that requires that intelligent granularization, it's going to have an impact there. And then finally, what we term longest legal citation. More and more of our clients are asking us for this, and I think it's something to consider while you're doing this type of a project. Essentially, what we do is we go through and we evaluate, and we find the most determinative, longest legal citation to kind of set the floor retention period. Anything that's any retention over that, we know is based on operational need, and that allows clients to kind of say, okay, we've got a gap, we've got a difference between our longest legal and our actual retention period. Can we reduce it? They can go out to stakeholders and say, okay, what's this operational need? We know that the legal requirement is only this. Can we reduce this at all, or do we have a valid operational need? So oftentimes that's something that clients consider and want us to include, and might be relevant to your project if you're conducting a project like this as well. And then I think this is the last slide, but don't let your work go stale. You need to every once in a while update this stuff and make sure that map citations are still good. Run searches for some new requirements, see if anything has changed since the last time you did research. Repeat out that whole mapping process that Jen explained for any newly discovered citations, and then consider those changes. So this process is something that if you're keeping up and maintaining your schedule, it will repeat at the interval that you feel best represents your risk considerations and your needs as far as keeping your schedule up to date. Okay, so that's all the material that we have for today. If you guys have any questions, here's the contact information for Jen and myself. Feel free to email us, reach out. We're happy to discuss any of these concepts with you and answer any questions that you guys have.
Thanks, everybody.